exhausted. Check, check. Good morning. The subcommittee will now come to order. This hearing is being convened to consider H.R. 3933, the Calling Card Consumer Protection Act of 2009. And the chair want to take a quick moment just to welcome all who are gathered, our witnesses, the audience, and also I want to welcome all the members to this hearing. And the chair now recognizes himself for 5 minutes for the purposes of an opening statement. The prepaid legal calling industry generates more than $4 billion in annual revenues. It is a highly fragmented industry comprised of well-known and lesser-known telecommunications companies that own and operate their own public and private networks, resellers of telecommunications services, and marketing firms and distributors who produce, brand, and deliver the cards to retail outlets and stores. The chair wants to take a moment to thank my friend and colleague from New York, Mr. Engel, for reintroducing this bill in the House. It would significantly improve the truthfulness of calling card advertisements and pave new avenues of recourse for millions of defrauded and vulnerable classes of consumers in this country. There's a familiar phrase that has been made infamous by the great businessman and showman P.T. Barnum. And he kind of succinctly put us in the proper framework for this time. There's a sucker born every minute. And these words have helped to set the theme for today's hearing. Batches of fraudulent calling cards enter the stream of commerce day by day. They represent the amount of calling cards that are supplied on the card and hide applicable fees and charges. They misrepresent the amount of the calling minutes that are supplied on the calling card and hide applicable fees and charges. At times, the cards may even provide substandard phone connection, ineffective PIN numbers, and non-functional or always busy customer service contact information. H.R. 3939 would remedy many of these problems. It would require calling card providers and distributors to accurately, clearly, and conspicuously disclose all relevant and applicable information on the cards. Such disclosures will include contact information for the card service provider, number of minutes supplied on the card, and dollar value of the card. And I again want to greet all the witnesses who are here with us today. And I thank them for taking time out of their busy schedule to be here. And I look forward to each and every one of your insights and to your views on this particular matter of H.R. 3993. And allow me to take particular pleasure today to greet Mr. Alie Kabba, who is a witness today. Mr. Kabba is the executive director of the United African Organization. He has worked devotedly from the organization's Chicago headquarters on behalf of the more than 100,000 African men, women, and children who now make their homes in Illinois. Okay, again, I want to thank each and every one of you for being here today. And with that, I yield back the balance of my time. And now it is my distinct honor to recognize the ranking member of the subcommittee, the gentleman from California, Mr. Radonovich, for 5 minutes.
Thank you, Mr. Chairman. I appreciate the fact that we're holding this hearing. And last Congress, similar legislation was ushered through the committee and onto the House floor in only a few short weeks before Congress recessed for the term. Doing so reflected our appropriate recognition that fraud and deception in a prepaid calling card market does exist and that it is necessary to address this problem. Intentionally taking advantage of consumers, whether they are immigrant groups or are military serving overseas, with prepaid cards that deliver less service than advertised is no different than stealing. If a consumer purchases a calling card expecting a certain amount of minutes minus the advertised fees, but later finds out that hidden fees or expiration of minutes reduce the value of what they purchased, this is at very least deceptive and quite possibly fraudulent. We certainly would not accept paying for a full tank of gasoline but driving away with only half a tank. This is not good for consumers, and it's not good for the legitimate businesses who make and sell these cards. Companies generally are not opposed to many of the requirements in legislation, as long as they are relevant and adhered to by all competitors. It is often the companies that cannot compete on price or service, however, that hide the fees or intentionally misrepresent the number of minutes the consumer is actually purchasing. This has got to stop. Consumers should have the necessary information to select the card of their choice and are often willing to pay more when they are knowing that they are buying a better service. The important point is that the consumers are able to choose based on available, truthful information. H.R. 3993 is intended to provide additional tools to the FTC and to the states to prohibit certain practices, require specific disclosures, and enforce violations of the Act. I agree it's important to provide meaningful tools to stop abusive or fraudulent practices, but given the available time to examine the legislation more thoroughly this year than last year's end of Congress frenetic pace, we should take the appropriate time to move through regular order and make necessary changes. As the FTC will testify, they have brought a number of cases, and the states have brought over 20 cases since the spring of 2008. This legislation could be helpful as a fraud deterrent, but enforcement of existing law will continue regardless of when Congress may enact legislation. I have concerns regarding certain provisions of the bill, and in particular the differences between this version and the one the committee considered in the last Congress. Consolidating enforcement at the FTC is good policy given their history of consumer protection and enforcement against unfair, deceptive practices, but to be effective, it requires a legislative change to the existing common carrier exemption under the FTC Act. And without that, the vast majority of prepaid service providers would remain outside the reach of the FTC. My concern regarding this provision is whether it effectively consolidates enforcement under the FTC or whether it leaves open the unwanted possibility of dual regulation by both the FTC and the FCC. And I hope that we can work to clarify this language. Additionally, and of more concern, is the change that permits the states to regulate the same activity as that proposed by this legislation. The states can and do enforce their own laws in this area. As a policy matter, the change to remove the preemption while enacting a new federal law is an obvious problem. We could respect states' rights and leave it to them to continue to enact and enforce 50 different sets of laws, or we can decide we need to have a strong federal law that provides a uniform and consistent regime that benefits consumers. Doing both will create conflicts and confusion that accompany up to 50 different disclosure requirements and will have little corresponding benefit, which is why I support the one federal standard. Additionally, there is concern that retail merchants who have no direct relationship or control over the disclosures required would be subject to this act. Mr. Engel's original bill defined distributors specifically to not include retail establishments that were engaged only in a point-of-sale transaction. This clarification is no longer the legislation, and I would like to hear the objections and providing such a protection. I'm not aware of other instances where a retailer is liable for the disclosures on a product it merely resells as a merchant. I would like to thank Mr. Engel for his commitment to this issue, and I look forward to discussing and hope to work on a bipartisan manner to improve the legislation. Thank you, Mr. Chairman. I yield back.
The Chair thanks the gentleman. The Chair now recognizes the gentleman from Ohio, Mr. Space, for 2 minutes for the purposes of the opening statement.
I'll waive my opening statement, Mr. Chairman. Thank
you. The Chair thanks the gentleman. The Chair now recognizes the Vice Chair of the Subcommittee, Ms. Schakowsky, for 2 minutes.
Thank you, Mr. Chairman. I'm very pleased to be here today to discuss the Calling Card Consumer Protection Act, and I congratulate my colleague, Mr. Engel, for introducing it and the chairman for holding this hearing. This bill moved very quickly in the Congress, passing the House easily by voice vote. I hope that we can move as quickly this time around as on this important consumer protection bill. Today, more than 276 million American households and 89% of the U.S. population have cell phones. But prepaid calling cards remain a huge industry worth $4 billion in 2007. They're particularly popular among college students as well as military personnel and immigrant communities, people who frequently make international calls. My district is one of the most diverse in the nation. Almost 1/3 of my constituents are foreign-born, first-generation American or first-generation American residents. So calling cards are very, very important to them. Unfortunately, the calling card industry is full of deceptive advertising and hidden fees. The Illinois Attorney General, Lisa Madigan, is currently investigating about a half dozen companies for their harmful practices. A card may say it's worth 250 minutes, but you could get 200 or 100 once you actually use it, or even 0 minutes. So, since some cards come with phone numbers that never connect or send you to a busy signal. Too often calling cards have no information listed about connection fees, varying rates per minute, fees charged each week that you don't know when you use the card, or even fees for just hanging up. Such abusive and unfair practices must stop. I look forward to hearing from our witnesses whether they believe the Calling Card Consumer Protection Act is sufficient or whether we need to go even further. I thank you, Mr. Chairman, and I yield back the balance of my time.
The chair now recognizes the gentleman from Kentucky, Mr. Whitfield, for 2 minutes for the purposes of the opening statement.
Thank you, Mr. Chairman. Well, we can see what a difference a majority has from the Republicans and Democrats, because we all supported the Engel bill. We passed it, I think, by voice vote in the last Congress. Wasn't that right, Mr. Engel? Yeah. And now I have to say that as much as I support the intent, I am a little concerned, obviously, with the federal preemption. And that's the area that I think many of us on this side are concerned. I know that Mr. Barton has also experienced some concern with that, too. This pre-card calling industry is a billion-dollar industry. There are some bad actors. Mr. Engel is to be commended for his bill. He's simply asking for accurate and reasonable disclosure of the terms and conditions of prepaid calling cards. So what could be wrong with that? Nothing. But let me just give you one of the concerns that I have. Unlike the one he introduced in the last Congress, the new version of the Calling Card Consumer Protection Act does not, let me repeat, contain federal preemption. Instead, this bill allows states to enact requirements, each and every state, that provide equal or greater protection than the federal standard. Given the small size of calling cards and the difficulties involved with having to fit lengthy disclosures onto the card, some in multiple languages, in a clear and conspicuous manner, companies may not be physically able to comply with both federal and multiple state disclosure requirements. So you have 50 states, and you're going to have 50 requirements, and you're going to have to reconfigure for each of those states. So I think we need one unified set of rules that will apply all players to all players on notice, really outlining what their responsibilities are to consumers. I think Mr. Engel would probably agree with that. And so I think this is a point we can work on together in a bipartisan manner to address this issue before we mark up. So I had urged the chairman, Mr. Waxman, and the ranking member, Mr. Rush, to consider that we have a well-intentioned bill that is something that everybody agrees with, but we need to have an understanding that in the area of preemption, we cannot have 50 states complying with all these multiple requirements for disclosures on the card, and perhaps in multiple languages. So with that, Mr. Chairman, I would say that it's a very good bill with that one reservation. Thank you.
The chair now recognizes the gentleman from North Carolina, Mr. Butterfield, for 2 minutes.
Thank you very much, Mr. Chairman, for holding this hearing, and thank you, Mr. Engel, for offering it. It's a good bill, and I support it. The bill increases the protections for consumers and will go far to ensure those who use prepaid calling cards know what they are buying and what fees and charges are associated with the use. I say all of the time, I represent the fourth poorest district in the United States of America, where the unemployment rate is just going out of the sky. Many of my constituents, some of the most, are the most poorest in the nation, and prepaid calling cards are used often by my constituents to communicate with their families. These are the same workers that clean our schools and harvest our food. They are the same people who are being preyed upon by despicable prepaid calling card companies. Large calling card companies sell these cards in various minute amounts, and what is not clearly disclosed to the consumer is the hefty connection or hang-up fees and other fees associated with each call. A $20 calling card promising to deliver 100 minutes, for example, could ultimately only yield a small percentage of the minutes. In fact, a 2008 study found that of the 45 prepaid cards surveyed, only 60% of advertised minutes were actually delivered. These predatory actions force hardworking people into a cycle of being victimized by the fraud and deception practiced by the prepaid calling card companies. H.R. 3993 provides greater transparency for prepaid calling card consumers. It's a good bill. I plan to support it and thank my friend Mr. Engel for offering it. I yield back.
The chair now recognizes the gentleman from Pennsylvania, Mr. Pitts, for 2 minutes.
Thank you, Mr. Chairman. Thank you for holding this hearing on H.R. 3993, the Calling Card Consumer Protection Act of 2009. Prepaid calling cards are used by scores of people in the United States, from college students to people with family and friends abroad to military personnel. American consumers spent roughly $4 billion on cards in 2007. However, a number of studies have found that there are serious flaws in some of the cards. Many do not deliver the full number of advertised minutes. In addition, cards sometimes lead to poor phone connections and provide toll-free and other call-in numbers that are busy or do not work. To address these problems, last Congress, the Energy and Commerce Committee considered H.R. 3402, which passed by voice vote on the floor. The bill we're considering today is similar to last year's, but there are a number of concerns with H.R. 3993 that I hope we can reconcile. Unlike the Senate version of this bill, H.R. 3993 does not explicitly limit the authority of the FCC where the FTC has jurisdiction under the bill. I believe it would be harmful to place duplicative and overly burdensome regulation on industry by mandating they be subject to both the FCC and the FTC. Additionally, preemption is essentially eliminated in H.R. 3993. The previous legislation only permitted continuation of state laws that are identical to the federal law. Under H.R. 3993, states are now allowed to enact requirements that provide equal or greater protection than the federal standard. Finally, not exempting retail merchants from the definition of distributor calls into question if the retail merchant industry is now liable for the same card disclosures required of the service providers and distributors. I hope that many of these concerns can be addressed before we move the bill. I look forward to hearing from the witnesses today, and I yield back.
The chair now recognizes the gentleman from Maryland, Mr. Sarbanes, for 2 minutes.
I waive my opinion.
The chair thanks the gentleman. The chair now recognizes the gentleman from Kentucky for 2 minutes.
Mr. Chairman, thanks very much, and we appreciate your having this hearing on this important legislation. The Federal Trade Commission estimates that approximately half of the $4 billion of industry revenue from selling these cards can be attributed to fraudulent gains. And so I do believe that this legislation is a step in the right direction, but like some others on the committee, I have 3 basic primary concerns. First of all, any industry operating in interstate commerce, I think it's imperative that there be federal preemption, because the last thing we want to happen is for a company have to deal with 50 different regulations on a particular card. The second thing that I'm concerned about in this legislation is the possibility of dual regulation between the FCC and the FTC. We all know the difficulty with bureaucracies, and without a clear, definitive understanding of which agency will be responsible, I think that's going to be a problem as well. And then the third thing that I do have a concern about is that the retailers who sell these cards, I think it's imperative that if they are knowingly involved in fraudulent activity, then obviously they should suffer the consequences. But I think it's very easy for retailers to sell these cards and not be aware of the fraudulent activity. And so I think that we should take steps to clarify that and make sure that they're not held liable if they're not knowingly aware of it. But I want to thank the chairman for his continued leadership in this effort, and for the ranking member as well, and I yield back my 9 seconds.
The chair thanks the gentleman. Now, seeing that there are no other witnesses, no other members who need to be recognized for opening statements, the chair now requests unanimous consent that the author of the bill, Mr. Engel, be allowed to sit in on the committee hearing and to participate in the committee hearing, and he will be able to ask questions at the conclusion of the questions by the members of the committee. Hearing no objections, so ordered. And the chair now recognizes for 5 minutes the author of the legislation, Mr. Engel.
Well, thank you very much, Mr. Chairman. I want to thank you for holding today's hearing on my legislation, H.R. 3993, the Calling Card Consumer Protection Act, and for allowing me to participate as a member of the Energy and Commerce Committee, but not a member of this subcommittee. I would also like to welcome Commissioner Acampora from my home state of New York for attending this hearing as well. And I appreciate the comments made by all of my colleagues in support of the bill, even though some may have some questions about certain parts of it. As many of us know, calling cards are an invaluable resource for people who don't have long-distance telephone service in their home, or those who make frequent overseas calls. Calling cards that provide the services that the companies advertise can save consumers a great deal of money when they call home. But unfortunately, as members have said this, as we're seeing over and over again, many companies fail to keep their advertised terms. About 3 years ago, I began hearing from a number of constituents regarding their prepaid calling cards. They were contacting me because their calling cards failed to provide the number of minutes that were advertised. In fact, many were not even close to delivering the promised number of minutes. In independent tests, calling cards were shown to provide far fewer minutes than were advertised. One study found that on average, the caller only received 60% of the minutes guaranteed by the card. I recently read that the prepaid calling card industry takes in $4 billion a year in revenue. If the cards are only providing 60% of the minutes, we can all do the math. This deception is costing consumers and honest companies hundreds of millions of dollars a year. Calling card fraud harms segments of the population, as my colleagues have pointed out, who are among the most vulnerable to being victimized by unscrupulous companies only seeking to make a quick profit. These companies are known to target poor, minority, and immigrant populations, and they don't stop there. Even our soldiers in Iraq and Afghanistan have been preyed upon by deceptive practices of calling card companies. My legislation would put a stop to these practices. It would also provide that the government is able to enforce the legislation to try to get rid of the dishonest companies. Calling cards are an extremely useful product for consumers, and I don't want to see honest companies punished. There's absolutely no reason why a company cannot deliver what is promised and still turn an honest profit. If consumers know that the card they purchase will provide the full amount of calling time that's advertised, this will benefit both consumers and the marketplace. And let me just say, I think that industry here should support this bill, not get bogged down with ridiculous reasons for opposing it. I commend those segments of the industry that are working with us, But the ones that are dragging their feet, if they have nothing to hide, if their calling cards are not fraudulent, then they should enthusiastically support this legislation. And I want to thank Senator Nelson of Florida, who is sponsoring this bill in the Senate as well. I would strongly encourage the members of the committee, of the subcommittee, to support H.R. 3993. I will show a flexibility in working with members to see if we can all come to a conclusion. But we don't want to water down the bill so much that it becomes ineffective. So I think that's the counter to what some of my colleagues have pointed out. But I do appreciate the bipartisan support for this bill, and I strongly urge members of the committee to support it. And I thank you again, Mr. Chairman, for holding this hearing today and allowing me to participate as a subcommittee member. And I yield back the balance of my time.
The chair thanks the gentleman. Now it is my distinct honor and privilege to welcome our witnesses for today's hearing. Beginning on my left, we have with us Ms. Lois Greisman. I think I pronounced it right. Ms. Greisman is the director of the Division of Marketing Practices for the Federal Trade Commission. Next to Ms. Weissman is Ms. Sally Greenberg, who is the executive director of the National Consumers League. And next to Ms. Greenberg is Ms. Patricia Acampora. She is the commissioner of the New York State Public Service Commission, and she is a member of the National Association for Regulatory Utility Commissioners. Did I get that right? Thank you. Okay. And next to Ms. Acampora is Mr. Alie Kabba, who's the executive director of the United African Organization. And then, lastly but not least, Mr. Scott Ramminger. He's the president of the American Wholesale Marketers Association. The chair wants to thank each and every one of you for appearing before this hearing. And it is the practice of the subcommittee to swear in the witnesses, and I will ask that if you would stand and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Please let the record reflect that all the witnesses have answered in the affirmative. And now the chair recognizes Mrs. Greisman for 5 minutes for the purposes of opening statements.
Thank you very much. Good morning, Chairman Rush, Ranking Member Dondich, members of the committee. My name is Lois Greisman. We on? You're good. We good? Okay. Thank you. I'm Lois Greisman. I'm the Associate Director of the FTC's Division of Marketing Practices, and I'm very pleased to appear before you today. As you know, the FTC's formal views are presented in its written testimony. My oral remarks and any answers to questions you may have reflect my own views and not those of the Commission or any individual commissioner. I'd like to take my time to update you on the FTC's prepaid phone card initiatives and to discuss the Commission's support for H.R. 3993. One need look only at the enlarged poster to your left, which was produced by defendants in one of the actions that the FTC brought, to see how problematic disclosures are in this industry. As is typical, the poster makes large, bold claims about the number of calling minutes consumers purportedly will receive in calls to specific destinations. For example, this poster boasts that consumers will receive 124 minutes to the Dominican Republic, 60 minutes to El Salvador. In fact, the FTC's testing showed that the card advertised here delivered, on average, only about half the advertised minutes. Now, that the card failed to deliver was due in no small part to an array of hefty hidden fees. Buried at the bottom of the poster in fine print that even if I were directly in front of it, I would be strained to be able to read, are lines of very small print that's so small and in wording so vague as to be nearly incomprehensible. So if an advertisement says that a card will provide 200 minutes of calling time to a particular country, it should do just that. Providing 100 minutes or less is unacceptable, and indeed it's illegal. Similarly, hidden incomprehensible connection, disconnection, maintenance, and other fees or charges are illegal. Last year, the Commission testified on the earlier version of H.R. 3993. Since then, the Commission has continued to scrutinize the prepaid calling card industry while working very closely with its 35 state partners and the FCC through the Federal State Task Force the Commission created back in 2007. As you've all noted, users of prepaid phone cards, whether recent immigrants, members of the armed services, students, or any one of us sitting here, are entitled to receive what they pay for. Several states, most notably Florida, Illinois, New Jersey, Texas, and California, have been particularly active in this area, investigating or filing many actions against both distributors and carriers to ensure that the marketing of prepaid phone cards is truthful and accurate. And at the same time, the FTC has continued its law enforcement efforts targeting prepaid phone card distributors, reaching settlements in 2 cases with nearly $3.5 million in monetary relief and strong injunctive relief. And just this past July, the Commission sued another major distributor, Diamond Phone Card, and its principals, making similar allegations as in the other cases. Now, as always, complementing the FTC's law enforcement efforts is a targeted consumer education campaign in both English and Spanish to ensure that purchasers of prepaid phone cards know what the cards are supposed to do and know what to look for when making a purchase. Turning now to the bill. H.R. 3993 is designed to provide accurate and improved disclosures, and further providing the Commission with civil penalty authority and creating the mechanism for states to enforce the law. It also would provide a strong set of tools to combat fraud in the prepaid phone card industry. Critically, the legislation creates a carve-out to the common carrier exemption that would allow the Commission to sue phone card providers, namely carriers, and obtain civil penalties and other relief against them. Eliminating this common carrier exemption for these purposes will permit the FTC to target a critical segment of the industry that in many cases, no doubt, bears liability for the widespread fraud in this industry. Indeed, as I've already mentioned, many of the state actions have targeted carriers. But, and at the risk of sounding ungrateful, the bill's exemption for certain prepaid wireless phone services is problematic. It creates a welcome sign for the worst actors in the industry, inviting them to migrate their business to prepaid wireless products. The nature of the wireless products and services, as well as the advertising and marketing for them, are strikingly similar to those outside of the wireless context. The same rules of the road should apply. Thus, taking prepaid wireless services out of the bill's regulatory coverage does not seem sensible and creates a strong incentive for mischief. I urge the subcommittee to reconsider this point. I very much look forward to working with the subcommittee and to answering any questions you may have. Thank you.
Thank you very much. The chair now recognizes Ms. Greenberg for 5 minutes for the purposes of opening statement.
Thank you very much, Chairman Rush and Ranking Member Radonovich. Good morning. My name is Alie Greenberg. I'm Executive Director of the National Consumers League. The National Consumers League was founded in 1899, which makes us the oldest consumer organization in the United States. As part of our longstanding interest in protecting consumers from fraudulent practices, we operate a fraud center where we accept complaints and educate consumers directly about fraudulent practices. Last year, we processed nearly 20,000 complaints. Included in those complaints were concerns that consumers had about prepaid calling cards. When we appeared last before this committee in September of 2008, we equated the prepaid calling card marketplace with the Wild West. A little over a year later, we are sad to say that the situation for consumers remains more Gunsmoke than Little House on the Prairie. We believe that H.R. 3993 will help protect consumers from fraud by strengthening disclosure requirements on these cards. While we would have liked to have seen outright prohibitions on a number of the most egregious business practices, including high billing increments, pricey connection fees, and binding mandatory arbitration clauses, we are heartened that the bill explicitly protects the rights of states to develop strong consumer protections. The rapid growth in the prepaid calling card industry, which is expected to bring in somewhere between $2 and $4 billion in annual revenues by 2012, coupled with loose regulation and often lax enforcement, has enabled consumer fraud to flourish. While these cards provide users with an alternative means of calling friends and family, many card providers employ false and deceptive practices and impose unconscionable terms. Part of the problem, we believe, is the ease with which con artists can enter the industry. According to Pablo Bresson, a Miami-based telecom consultant and prepaid calling card distributor, it costs as little as $20,000 to buy the long-distance minutes and back-end consumer platforms to get into computer platforms to get into the business. Some companies do not even go that far. They simply resell the cards made by others. The potential for fraud in the prepaid calling card industry is so well known that it even merited a mention as a preferred scheme on HBO's The Sopranos, with Tony Soprano calling the scheme he was running blankety blank beautiful because it's so easy to run the scam. Fraud is fraud. If a car is sold with the promise of a sunroof and chrome wheels, it better have a sunroof and chrome wheels. And if a phone card promises 500 minutes to El Salvador, it should deliver those 500 minutes. The ultimate victims of fraud and deception in the prepaid calling card market are the most vulnerable consumers: immigrants, working poor, military families, and those with lower incomes. By some estimates, Hispanic consumers alone may be losing $1 million per day because of the fraudulent phone cards. Independent analysis by the Hispanic Institute and the FTC found that the average calling card only deliver between 50 and 67% of the minutes advertised. The cost per minute rates for prepaid phone cards can be up to 87% higher than expected, and an expected call rate of 15 cents per minute, for example, may end up costing 28 cents per minute. Now, some attorneys general have done a commendable job in prosecuting fraudulent practices, including in Florida and Texas. The Federal Trade Commission has also conducted investigations, as Ms. Greisman has pointed out, and has worked very closely with the states, and we commend them for that. While the FTC and state actions in this area have certainly benefited consumers, we fear that millions of dollars in losses continue to flow into the pockets of scammers. And also that calling card fraud too often goes underreported or unreported, and that is why we need basic federal protections to stem the tide of the many deceptive practices in the industry. NCL believes that giving the FTC greater authority, as called for in H.R. 3993, would help to level the playing field for providers. As called for in the bill, the regulation should also include requirements that providers and distributors disclose the terms and the conditions of the cards and list the per-minute rates, preferred international destination rates, and any fees or surcharges. In short, we believe consumers should know what they're buying, what they get, what they pay for, and have an accessible avenue for redress if they're harmed. We want to add some recommendations onto what is already available in H.R. 3993. First, with regard to disclosure, we recommend that this section of the bill be expanded to include a requirement that every calling card provider publish a website listing the card's rates, taxes, fees, and surcharges. Currently, Section 3A of H.R. 3993 only requires that providers list rates if they maintain a website. Secondly, if the GAO study mandated in Section 8 of the bill presents evidence indicating that greater disclosure has not curbed the abuses, we recommend further action be considered by this committee. And specifically, we'd like the committee to consider requiring all credit card providers to be licensed and post a bond before marketing cards to consumers. Such a move would address the issue of the extreme ease of entry into the industry, which invites fraudsters. Secondly, we would like to require all providers we think there ought to be a requirement that providers have a 24-hour, 7-day-a-week toll-free consumer line staffed by live representatives that are fluent in the language the card is marketed in. Third, we would like to see a provision requiring sellers to inform consumers via website or toll-free phone number of any proposed changes in terms and conditions, with consumers given the chance to reject those changes and receive a refund without a fee. Fourth, we'd like to see a requirement for uniform terms in all prepaid calling card contracts so that consumers can more easily comparison shop. And finally, we'd like to see a prohibition on binding mandatory arbitration and preserving a private right of action. Thank you, Mr. Chairman. We look forward to answering any questions and working with the committee to see this legislation enacted.
The chair thanks Ms. Greenberg, and now the chair recognizes Ms. Acampora for 5 minutes for opening statements.
Thank you, Chairman Rush, Ranking Member Radonovich, Mr. Engel, and members of the committee. My name is Patricia Acampora. I am Commissioner with the New York State Public Service Commission. I am testifying today for the National Association of Regulatory Utility Commissioners, or NARUC. NARUC represents the agencies in each of your states that have oversight responsibilities for telecommunications. These commissioners are, like you, all focused on what is best for your state and your constituents. On behalf of NARUC, I want to commend Chairman Rush, Ranking Member Radonovich, and Mr. Engel, my fellow New Yorker, for their leadership on this important issue. We want to specifically thank each of you, in particular your excellent staffers, Brick McDarren and Anna Layton. I have submitted written testimony, but in my oral remarks I will briefly touch on why this is a good bill and then provide a few suggested improvements. H.R. 3993 is a good bill. Abuse in the prepaid calling card market is well documented. By definition, the fraud and inadequate disclosure problems targeted cannot be handled by market forces. That's why reputable providers that make up the heart of this industry should embrace the joint federal-state enforcement regime presented. The federal-state partnership established in Sections 5 and 7 of the bill is critical. It maximizes the avenues for consumer redress. It assures states don't waste tax dollars reshuffling existing enforcement regimes. It allows more protective state fines and remedies to remain intact. It leverages state and federal enforcement activity to produce the greatest possible deterrence to bad actors. There is never a good reason to take state consumer cops off the beat or to limit your constituents' avenues for redress. H.R. 3993 does neither. Significantly, the bill also mandates disclosure of all information that consumers need to make informed decisions, and also federal and state authorities need to investigate bad actors. This legislation is, in fact, an excellent template for how federal and state authorities can best partner to protect consumers. This is a good bill, and NARUC supports it. That said, I do have a couple of personal suggestions and one NARUC proposal to further improve what is already a very good bill. NARUC suggests changing the definition of prepaid calling card and calling card service. The current definitions reference existing regulatory classifications that are increasingly outdated as technology evolves. Definitions that reference specific technologies like VoIP and old classifications can only serve as target for bad actors to find loopholes, something history has conclusively demonstrated they are very, very good at. The subcommittee should focus on a functional definition that is not tied to any particular technology like the one used in Senate Companion Bill S562. That approach was also used by Representative Engel in H.R. 1258. I also have a couple of personal recommendations. My commission and others have difficulty pursuing prepaid calling card complaints because the rates and fees information related to the card is printed on the packaging, which is normally thrown away. I would like to commend Congressman Engel as this bill fills the gap by requiring that disclosure of rates and fees, as well as contact information, be printed on the calling card itself, not just the packaging. Further, if the disclosure printed on the card is obscured by the packaging, this legislation requires the disclosure also be printed on the packaging. However, I remain concerned that providing full disclosure on the calling card itself may result in unreadable print size. To improve the readability, I suggest service providers be required to include all rates and fees on a piece of cardstock included with the calling card. This card should be the same size as the calling card and have the phrase, "Consumer, do not discard," printed on both sides in large type. Another personal recommendation would be to require all calling card providers to maintain a website with information on the rates, terms, and conditions of the card, and the website to be displayed on the card. As currently drafted, the bill only requires online disclosure if a provider maintains a website. This opens the door to abuse. It's not unreasonable to require a provider to maintain a website outlining rates, terms, and conditions. It's certainly not expensive nor difficult. Thank you again for allowing me to have this opportunity to testify.
The chair thanks Ms. Acampora. Now the chair recognizes Mr. Kabba for 5 minutes for the purposes of opening statement.
Mr. Chairman, members of the Subcommittee, I'm Alie, Executive Director of the United African Organization and also Vice President of the Illinois Coalition for Immigrant and Refugee Rights. Mr. Chairman, I'm Alie Kabba, Executive Director of the United African Organization and the Vice President of the Illinois Coalition for Immigrant and Refugee Rights. Thank you very much for the opportunity to share my perspectives on prepaid telephone cards. This hearing is very timely. The United African Organization and the Illinois Coalition for Immigrant and Refugee Rights recognize that prepaid phone cards are often the only means for immigrants from Africa, Asia, Latin America, and the Caribbean to stay in touch with family members abroad. The cards are generally marketed through ethnic stores and neighborhoods with significant immigrant populations. They are easily accessible and, on the surface, cheap compared to rates by major providers. However, appearances are often deceiving, particularly for consumers with limited English proficiency. Prepaid phone cards too often do not provide the actual minutes of advertised or announced due to a myriad of fees. Limited English proficient consumers, including immigrants, refugees, and the low income, are faced with unnecessarily small fine prints to decipher associated usage fees. By all accounts, prepaid phone cards are predominantly used by some immigrants who can't qualify for phone service from major providers like AT&T and Verizon, because they lack needed documentation or they do not have credit history. Alas, Mr. Chairman, this vulnerable group of undocumented consumers of prepaid phone cards is the least likely to complain about poor customer service, deceptive practices, or deficiencies associated with use of the cards. Fees may not always be fully disclosed, and even if they are disclosed, they usually are not understood. When you factor in the problem with low completion rate of calls, hidden fees can easily account for a hefty portion of the cost per call. Short expiration dates have become a pervasive practice, presumably to increase calling card sales. Unsuspecting consumers are out of minutes if they hold on to the cards beyond the short expiration dates. Immigrant customers are likely to buy a few extra cards in case of a family emergency in faraway places like the Democratic Republic of Congo or Trinidad and Tobago. The short expiration dates often leave customers with worthless cards due to no fault of their own. Short expiration dates are sometimes related to yet another hidden problem with prepaid phone cards. Some calls do not simply reach their destinations. An unsuspecting customer may try repeatedly over an extended period of time to reach their loved ones in, say, Bolivia or Liberia, without giving much attention to the expiration dates. Consequently, they are hit with the double whammy of losing their money and not able to talk to their loved ones abroad. Cost per minute rates are often too higher than those advertised. The joke in the community is that it does not matter whether the prepaid phone card is marketed under the brand name of African Safari, African Kilimanjaro, or African Sky. The actual cost per minute is as mysterious as the night sky over the Sahara Desert. In other words, prepaid calling cards are like books whose covers tell you nothing about their content. You simply hope and pray to the Holy Spirit that you'll have your money's worth. And to add insult to injury, Mr. Chairman, customers have no recourse to lodge their complaints. Even in the rare instances where you can reach a customer service department, customer service personnel may not be available or their customer base or their customer, of course, customer service department speak the language of the customers. Since a significant percentage of their customers consist of limited English proficient households with at least one relative abroad, it flies in the face of logic that many prepaid phone card providers do not have customer service departments or departments with linguistically competent staff. This lack of commitment to customer needs implies a cynical business strategy relying on a captive customers who will accept cutthroat rates and poor service because they have no viable alternatives. There is the perennial complaint about billing increments, the units the companies use to deduct minutes. For example, if using one bill increment on a 5-cent per minute card, it deducts 5 cents for the card, even if the call lasts for 1 minute or just 30 seconds. If the card applies a 5 billion increment, that same 30-second call could cost 25 cents. Clearly, the customer ends up with fewer minutes than previously advertised. It is crystal clear that the empirical basis of the above consumer complaints point to one conclusion. Information provided by prepaid phone card issuers is often confusing, incomplete, and deceptive. In conclusion, in requiring accurate and reasonable disclosure of the terms and conditions of prepaid telephone calling cards and services, we strongly believe that H.R. 3993 addresses all pertinent consumer complaints in our diverse immigrant and low-income communities. Furthermore, we believe that careful wording of what is meant by truthful disclosure of minutes available is imperative if per call and periodic fees are allowed. If fees are allowed, there must be standardization of terms and only one term for each fee. Consumers should have better information prior to purchase. Prepaid phone card providers can facilitate this process by using simple, plain English. Thank you, Mr. Chairman.
The Chair thanks the gentleman. The Chair now recognizes for 5 minutes Mr. Ramminger for the purpose of the opening statement.
Thank you, Mr. Chairman. I'm Scott Ramminger, President of the American Wholesale Marketers Association. Our association represents distributors to convenience stores across the country. Our members supply about $85 billion worth of product through convenience stores like 7-Eleven, for example. Simply put, they purchase products from manufacturers. They purchase snacks and candy and tobacco products from the manufacturers. They aggregate that product and deliver it and sell it to the convenience stores. And of course, one of the things that they do along with the consumable products is supply some of these prepaid calling cards, which they purchase from the manufacturers of those cards. On behalf of AWMA, I'd like to thank the subcommittee for holding the hearing and for working to ensure that consumers are protected from unfair and deceptive practices with respect to these cards. We support that goal wholeheartedly. However, we would like to urge that any legislation ultimately approved by the committee include language that imposes liability for false labeling or advertising on our member distributors only if they know about this falsity. Unfortunately, the legislation currently before the committee contains no such provision providing this necessary protection for law-abiding distributors. Under the current legislation, H.R. 993, a distributor, much like a retailer, would be held liable and could be punished simply by acting as a conduit, purchasing these cards from the manufacturer and supplying them to the convenience stores, even if the distributor was completely unaware that there was any sort of discrepancy or problem with the cards. This would create an unfair burden of liability for the distributors, and I would urge the committee to ensure that legislation promoting the consumer protection on the prepaid calling cards includes protection for the law-abiding distributors who unwittingly could be acting as go-betweens on these products. The H.R. 993 would add the subject of calling cards to the Federal Trade Commission Act. directs the FTC to write a rule governing calling cards and spells out the consumer disclosures that calling card vendors must provide. The penalties for violation of the FTC rules are injunctions, money damages, and fines. The bill gives states attorney general similar authority. We believe that it's only fair that wholesale distributors are exempt from liability for incorrect disclosure if the distributor has no control over the scope or services that the manufacturer has delivered. Well, it's true that a distributor could tell whether or not there is a clear and conspicuous notice on the card about fees and minutes. The distributor would have no way of knowing whether, in fact, the card had the correct number of minutes on it or not. In previous Congress, a similar bill on this issue, H. 3402, addressed the problem by making it unlawful for the distributor to distribute the cards if the distributor knows that the prepaid telephone card provides fewer minutes than the number promoted or advertised. As I said, unfortunately, this new bill does not have this much needed provision. On behalf of our members of the American Wholesale Marketers Association, I'd like to offer the following fix aimed at ensuring the fairness and reasonableness of the measure. Section 2, parentheses 4, defines prepaid calling card distributor. This section could be amended by adding the following clause at the end. But such term does not include distributors who sell such cards in the same form and packaging as acquired from a prepaid calling card service provider or distributor. Alternatively, a provision could be added to the directions given to the FTC that would read, in promulgating each such regulations, the Commission shall not issue regulations which hold a prepaid calling card distributor liable for deceptive disclosure of services or rates which the distributor was unable to know or control. And I would just like to add, I think there's a little bit of nomenclature problem perhaps, because sometimes our members who are real wholesale distributors who are purchasing typically goods, canned goods or candy from a manufacturer and reselling it, we refer to as distributors. And sometimes the makers of these cards are referred to as distributors. We're talking about two different sorts of distributors entirely. Our guys are not buying the minutes and producing the cards. They are buying the cards from someone and simply selling them along with other goods to the retailer. I again like to commend the subcommittee for these efforts. It's clearly an important issue. I represent small businesses and clearly can appreciate that this is a significant problem. And I hope you will consider our concerns as you go forward on this important issue. Thank you, Mr. Chairman.
The Chair, thank you. And the Chair thank all the witnesses for their fine opening statements. Before we begin our line of questioning, I request unanimous consent with respect to the submission of two items that was submitted to the subcommittee for entry into the record of today's hearing. Item number one is a statement for the record of Mr. Walter B. McCormick, Jr. He's the president and CEO of the U.S. Telecom Association. And the second item is a statement and the comments for Mr. John Eichberger. He's the vice president of the National Association of Convenience Stores. Hearing no objection, so ordered. The Chair recognizes himself now for 5 minutes.
Mr. Chairman. Mr. Chairman.
No,
could I ask unanimous consent to submit my opening statement for the record?
Hearing no objection, so ordered. The Chair recognizes himself for 5 minutes. And the Chair directs his question to Ms. Greisman. Ms. Greisman, this legislation provides the FTC with authority over common carriers solely for the purpose of enforcing the provisions of the bill. Although the FTC is generally prohibited from exercising any authority over common carriers, there is precedence for this kind of carve-out authority. as a similar power was given to the FTC regarding pay-per-call services. The question that I ask of you is, what could the FTC do differently if it had this special carve-out authority regarding these fraudulent calling cards?
Mr. Chairman, the answer is very simple. It could sue carriers, which it cannot currently do. The 3 cases brought by the FTC have been against prepaid phone card distributors. We do not have the statutory authority currently to sue the carriers, many of whom we believe are also responsible and should be held liable for the fraudulent claims that were made.
In your testimony, you argue for a complete repeal of the common carrier exemption. Why do you believe that this is necessary?
We think that exemption is outdated. The telecommunications industry today looks incredibly different from how it looked back in the early 1900s. We see convergence among telecommunications and internet service providers, and we simply think it does not make sense, and it actually impedes our law enforcement activities, as it has in the prepaid calling card context, and it complicates litigation, which we've seen in cases where we've brought involving cramming, which is the unauthorized placement of charges on telephone bills.
Are there any other witnesses who have either similar or contrary comments or answers to this question? Are there any other witnesses who would like to comment on Ms. Greisman's response to the question?
Mr. Chairman, in our testimony, we support the carve-out for the specific purposes of allowing the FTC to have jurisdiction over the common carriers in this situation, because they play a big role in servicing the consumers who buy these cards. So, yeah, we do support the FTC's role in this area.
Anyone else? Any other comments? I will move to another line of questioning here. Mr. Kabba, for many immigrants living in the U.S., and you've clearly stated it, but I want you to state it again, but it's not only immigrants. We got college students and military personnel. And for these people, the prepaid calling card is the primary method for staying in touch with families and friends. But as been stated earlier, prepaid calling cards in most instances, or in many instances, fail to deliver the full number of advertised minutes. For example, in 2007, the Hispanic Institute conducted a study and concluded that on average, a prepaid calling card offered the consumer 60% of the minutes that were advertised. And, of course, this is totally unacceptable. What remaining time I have, I want to dig into the impact that these fraudulent calling cards can have on American consumers. You represent immigrants in Chicago. What impact do these fraudulent cards have on the many immigrants that you help on a day-to-day basis?
Clearly, if you look at the deceptive practices, what we see on a daily basis in our communities is that the generally low-income households tend to lose more money than the service they get in return. And I think that this is important to know, because these are the households that really need to divert significant portions of their household income to basic necessities, to food, to making sure that they can pay their rent and not be homeless, to paying for childcare, for their children, who they need actually to have a place before they can go to work. And so when we look at the complaints that we receive every time, Mr. Chairman, it is clear that there is indeed an outflow of income from these households to businesses that are clearly not providing the services that they purport to provide for the community. And more importantly, I think that it sends a message that in our communities at least, that there is no recourse for these households to turn to. in terms of their legitimate complaints. And this, I think, bill helps us to deal with that problem, because if indeed there is a way for them to call a place, even a toll-free number, that is dedicated to customer complaints that we can direct them to, that will be far more empowering and help them to know that they are not vulnerable to these predators, because that is really what the practice is. Each card comes in different names, and you are tempted to buy the card that perhaps associated with your homeland. If you are from Trinidad and Tobago, you see a card that talks about some Trinidadian music, and you think, oh, that is great, Calypso, and you buy it. But then it's really the same thing as African Kilimanjaro, but it's targeted towards these households that are not able to really react to the deceptive practices that we have documented. And these documentations, in fact, have been highlighted in the University of Chicago study in 2004, which clearly support many of the statements that you've made here, that people who buy phone cards generally do not get their money's worth. And so we are really talking about a community that is significantly losing money and not getting the services. And I think this bill will help to stop that bleeding from their households.
The chair's time is up. The chair now recognizes the ranking member, Mr. Radonovich, for 5 minutes.
Thank you, Chairman Rush. Welcome to the subcommittee. I appreciate all of your testimony. Ms. Greisman, if I may, I'd like to quiz you on one particular item, and that is the retail end of this concern and legislation. During the floor debate last year, the gentleman from New York, Mr. Engel, the author of the bill, stated very clearly that he believes that the intent of the legislation, at least last year's legislation, was to address the bad actors manufacturing these cards and not go after mom-and-pop retailers. And I commend him for his hard work on this legislation and efforts to target the source of the problem. And, Mr. Chairman, I do have a transcript of a colloquy that was done on the floor with, by Mr. Engel and I believe Mr. Whitfield, and I'd ask unanimous consent to submit that for the record.
Hearing no objection, so ordered.
Thank you, Mr. Chairman. My question is, does the FTC concur with Mr. Engel's policy intent on this legislation to exempt retailers?
Speaking on my own behalf, which is all I can do at the moment, yes, that is consistent with my understanding of the bill.
All right. And so you do agree that mom-and-pop stores who've done nothing wrong, but rather than they shouldn't be on the hook for the bad actors?
They've not been a target of the FTC enforcement, and I would not anticipate looking toward them in any foreseeable future.
Okay. The FTC staff provided technical comments in a red-line version of H.R. 3402 in the previous Congress. The Commission's comments did not delete the original language that carved out retail merchants only engaged in point-of-sale transactions with consumers, but rather only made a technical change to it. The language was removed as it moved to the House floor for consideration. Does the Commission believe that there's any harm if that limitation is placed back in the legislation?
I would have to look at the precise language. I don't remember it specifically.
If it were as simple as just making sure that retailers were not, mom-and-pop stores and such were not liable under this legislation.
Our concern in that context, I believe, would be that a carve-out just is not needed and it's not necessary, and as a general matter, we disagree with carve-outs to bills.
So you did the FTC support the deletion of the exemption?
I honestly don't remember. I will have to check.
If you can get back to me on that would be great. Thank you. What's the current civil penalty for violation of Section 18 of the FTC Act?
$16,000 per violation.
Mm-hmm. Does that mean that without some sort of legislative limitation, such as a definitional exemption or injunctive relief for not knowing violations, that mom-and-pop stores or bodega stores could be liable for up to $16,000 if it unwittingly sells a $5 prepaid card that omits particular disclosures?
Under the Federal Trade Commission Act, there is a knowledge standard that the FTC would have to satisfy in order to impose a civil penalty on any entity.
Mm-hmm. Would the FTC support amending the bill to include a retailer exemption? I'm sure you addressed that before, but are you speaking as a commissioner or as the commission? Or
I'm speaking solely on my own behalf, and on my own behalf, I do not believe we would support that.
Because you feel that that exemption is not necessary.
Correct.
Alternatively, would the FTC support limiting relief against these point-of-sale retailers in case of non-knowing violations to injunctions similar to the limitations for state actions in the bill?
I'm sorry, I'm not sure I follow your question, sir.
Would the FTC support limiting relief against these point-of-sale retailers in cases of non-knowing violations to injunctions, similar to the limitation of the state actions in the bill?
I think for the same reasons I just stated, that as a general matter, we disfavor any particular exemptions. We probably would not support that.
All right, thank you very much. And, Mr. Chairman, I yield back.
The chair thanks the gentleman. The chair now recognizes the ranking member, Ms. Schakowsky, for 5 minutes for questioning.
Thank you, Mr. Chairman. I want to give a special welcome to Mr. Kabba. I like to welcome people from our hometown, but also to say that I've worked very closely with the Illinois Coalition for Immigrant and Refugee Rights, and I appreciate your work. And again, as I said in my opening statement, it has particular resonance in my district, which is so immigrant rich, and people coming from all over the world. Who was it that talked about technologies not being too specific? Was it you, Ms. Greenberg? Oh, you did. My understanding is that, and I don't know if they exist right now, but actual telephones, cheap telephones that instead of cards that could be sold. In other words, you instead of a card, or are there technologies where it would have exactly the same effect, but this legislation wouldn't cover it because it's not a card? Is that what you were concerned about?
It was being not so specific because technology keeps changing. So actually we recommended the language that was in the Senate bill, which doesn't go into some of these technologies because technology keeps changing.
Are you referring to a card versus something else? Is that what you're saying?
Could be, yes, could be. That there will be changes, so it won't be a card. And so that if the bill is just specific, you're leaving loopholes open to these people who are very inventive and who are the bad actors. They will find the loophole in the law, and they will look to do something else.
Ms. Greisman, would you comment on that as well?
We would have to take a look at the specific language of the bill. I can't address whether there are any loopholes at the moment. It's certainly something we'll look into.
Well, at the moment, but I'm wondering if you could, if you have any advice on drafting legislation that would have some staying power.
Yes, we specifically do oppose the exemption for wireless prepaid providers.
Okay. Let me see. When you said that there are no remedies, Mr. Kabba, do you see any? Is that a matter of consumer education in your view, or the fact that there really aren't any remedies right now, that people are left at the mercy of the calling cards companies?
It's really the fact that. Thank you. It's really the fact that. Currently, there are no remedies. All across diverse communities, we see this. The fact that we do not even have one standardized place for people to turn to, even if it's a toll-free number that we can say this complaint can be lodged there. That, I think, will be helpful. The consumer education is not as difficult as would imagine if we have clear language, simple, clear language from the providers. The fact that they're using extra fine print in language that we do not even, as advocates, understand less, So when you're talking about limited English proficient households, that in effect makes it harder. But I do know that right now the fact that there is no way to lodge complaints, and when we're dealing with cards that keep on changing their brand names to target households, making sure that, yes, people who are from Asia can feel like, oh, this card is special because it has something that reminds them of their home, or in the case of Africa, come up with a card name when in fact it's really the same provider if you read the fine print. We need to make sure that we really have a place to lodge complaints.
Okay. Does the state of New York have any remedies? And I'm assuming because you're here, your view is that national legislation certainly would be preferable.
We do have a law, and of course our law, as compared to what a new national standard would be less. But we do like the flexibility issue for states because, as I said in my statement, the state cops, when something happens, people are coming to the local officials. And so that the flexibility that allows us to address a problem right away is crucial. But the uniformity is still a good thing to have. We still could use more teeth in legislation, yes.
Okay. Thank you. Ms. Greenberg?
Yep. I think Mr. Kabba mentioned an interesting idea. One thing we might think about is having a statement on the card. If you have issues or concerns about use of this card, call this toll-free number. And it could be a place that would log complaints and see which providers are raising the biggest or creating the biggest problems. I think we begin to have a database of where the ripoffs were happening. And one other thing,
and would the FTC be the right place for that?
Whether we'll see if Ms. Greisman agrees to that, and she probably won't on the spot. But yeah, I would think it would have to be a federal clearinghouse for this kind of information. One other thing I want to say is that I lived abroad for a year. I lived in Australia, and when you buy a calling card there and it says you're going to get 500 minutes, you always get those minutes. So this is not rocket science. It can be done. They just have tougher regulations. And here, I use cards here all the time, and routinely they use them once, the values dissipates almost immediately. So I know this can be done, and I'm sorry to use up up your time.
Yeah, no, my time. Although, Mr. Chairman, if we could later, I do have want to address.
The chair wants to inform the vice chair that we will have a second round for 2 minutes each for each member to ask a second round of questions. The chair now recognizes the gentleman from Pennsylvania, Mr. Pitts, for 2 minutes. 5 minutes.
Thank you, Mr. Chairman. Ms. Greisman, the FTC works with the FCC and state AGs and other state and local agencies to combat unfair and deceptive calling card practices. How do all these agencies divide up enforcement responsibilities? And with all these entities involved in enforcement, do you end up with duplicative efforts?
No, sir, we do not. Dual federal state enforcement really is more the norm than the exception, and we see that most particularly in the telemarketing area, where this type of dual enforcement scheme has been enormously effective and productive. And in fact, working through task forces, such as the prepaid phone card task force that we created back in 2007, we do allocate resources and share information and work in a very cooperative manner.
Do inconsistent state laws place service providers in an untenable situation by prohibiting activities in one state that are permitted in another? Are prepaid calling card services usually tailored on a state-by-state basis, or are they generally uniform throughout the United States?
What I can say is that there are 11 states currently that have specific statutes or regulations addressing the prepaid phone card industry, and I'm not aware of problems that those different laws have presented or posed. Would
it be easier or more efficient to coordinate with the states on enforcement actions if there were a single standard? If there's a single standard, isn't it easier to catch fraudulent actors?
I don't believe that's necessarily the case. I think what we have now are different standards among the various states and at the federal level. And, for example, in the telemarketing area, that has not been a problem at all.
Now, Mr. Ramminger offers two proposed solutions to the concern of distributor and retail merchant liability. And his proposals involve either a change to the definition or a change to require the FTC to address it through its required rulemaking. What do you think of those proposals?
Well, I would like to take this opportunity to correct a misstatement I made in response to Mr. Radanovich's question. Actually, as I understand it, the way distributors currently is defined in the bill is a way that would exclude pure retailers, which I think gets at an issue that was raised earlier. I would have to look at the type of proposal that Mr. Ramminger is proposing with respect to distributors. But as a general matter, as I said before, my position is that we would not favor excluding any particular entity. And the 3 cases the FTC has brought have, in fact, been against distributors.
Ms. Greenberg, at what point do too many disclosures overwhelm consumers to the point where they disregard them or never read them?
Yes, sir. That certainly is a concern, and that's why we recommended something much more uniform, some sort of uniform text on every card, because with the fine print, as we can see there with this very good example, at some point it's too small to read, and people don't really know what to do with the information. So, if we could have some uniformity on these cards, I think that would be a great benefit to consumers.
And as Mr. Kabba said, it should be in simple, plain English.
That's correct.
Yeah. Should calling card companies not be allowed to set their own rates and fees as long as they disclose them completely?
That's a question for me. This is why we call this the Wild West, because right now these companies can set whatever fees they wish. They can promise that the rules can change at any moment. So we're really calling for much more oversight both on the part of the FTC and in this bill to try to curb some of the worst practices.
Mr. Kabba, do you know if the FCC has received complaints about the prepaid wireless market? And if so, do you know what the FCC has done to resolve those complaints?
No, not to the best of my knowledge, but I do know that it's a concern to us, and I hope that there will be some standardized way for us to really lodge those complaints.
We don't have much time, but what percentage of the market would you say, Mr. Kabba, are bad actors?
At this point, I can really say that the vast majority, and that's why this problem needs to be addressed. And I really commend the subcommittee for focusing on it. It's very hard to really pick out the good actors. Last month alone, I used probably 4 different cards, and I can assure you that all the cards did not deliver the number of minutes. So this is not a case where you have a good apple in a bag of bad apples. It's really the bag that we need to look at, the whole bag.
My time's expired. Thank you, Mr. Chairman.
The chair now recognizes Dr. Gingrich for, Mr. Stearns, I'm sorry. Mr. Stearns for 5 minutes.
Thank you, Mr. Chairman. Ms. Greisman, under the law, the jurisdiction of the FCC and the FTC would share jurisdiction, but I don't think they necessarily overlap, if I understand. If the jurisdiction in this area was to overlap, for instance, by removing the common carrier exemption so that the FTC can bring actions against FCC-regulated entities, the question would be, could common carriers find themselves at risk of being compliant with one agency's rules, but subject to a different enforcement regime by a different agency enforcing the same rule?
I don't believe so, sir. I think the rules of the road would be remarkably consistent, and that's what we've seen in the telemarketing area, where both the FTC and the FCC enforce very similar rules involving the telemarketing industry. And I don't believe we've seen any consistent or any inconsistent or duplicative efforts. For example, I think Do Not Call is a prime example of that.
Would the FTC support the inclusion of language that is similar to that in the Senate bill that essentially limits the FCC enforcement in this area where the FTC enforcement authority exists?
I don't recall that specifically in the Senate bill, but the FTC's.
My staff said it's in there.
Okay.
So
I certainly take your word for it. I just don't recall it myself.
Let's just go into that assumption. I think people in the audience are nodding, so let's just assume that, and then just see if you can answer the question with that premise in mind.
If I understand your question, the FTC's view is that the common carrier exemption is outdated, and lifting it will not create inconsistent or duplicative enforcement efforts by the FTC and the FCC.
Mm-hmm. I think this is probably a reiteration of what you've already answered, but you've testified it's never a good idea to limit. This is for Acampora. You've said that it's never a good idea to limit state consumer protection. However, without preemption, isn't it far-fetched to see that if disclosure is required by the federal government and even 1/3 of the states, let alone all 50, that the legally required disclosure can end up looking something much like that poster over there? And I think it suggested earlier that people obviously are not going to read it if it looks similar to that poster over there. You suggest requiring disclosure on card stock. And I guess the question is, would the card stock distribute with cards, will the card stock distributed with cards have to be as big as that poster to fit all those disclosures? I mean, that's what we're thinking about.
Well, the card stock would be the same size as the calling card, and it would simply have on there the warning to consumers not to throw that card out, and it would have information for them, which sometimes is on that packaging, gets thrown out, and then they can't see it. So we thought, we've kicked this around at the NARU committees from commissioners from all the states, and this is something that was brought up that everyone agreed with could be helpful.
You've closed on a house before, and did you read all the fine print on the mortgage statement, on the disclosure? You know how complicated it is? Sometimes it's 30 pages.
I didn't, but my husband did.
Yeah, or you're having a lawyer do it. It's
No, he's not a lawyer, but he's a very precise man.
But most people have a lawyer. I mean, at the rate we're going to have that card, you're going to need a lawyer once you buy the card. You get the whole thing, you're going to need a lawyer to see what it is. I mean, obviously, wouldn't you think you want to make it simplified?
I think this is simplified.
With 50 states having separate, different connotations on a card?
Well, you have to give the states flexibility. I mean, we like the idea of the federal government having a standard.
Now, remember, we passed this bill without this, by unanimous agreement in this. So both the bipartisan bill, the Engel bill passed, everybody supported it without what you're requesting. So I think.
Well, you're jumping from card to now to the various degrees. So let's just look at the flexibility that states need. But also, I believe in the bill, the language, the federal law would prevail if there was a problem.
All right, as I understand it, that each state would have the flexibility to do what they want in the federal law.
They do, but if there was a case where it was brought to where the federal government would be involved, the federal law would prevail.
Okay, my time's in. But you would agree that something that complex on a small card would be very difficult to convey to
That wouldn't be on the small card. The information that consumers would need to make a phone call or to go on a website, that's the information that would be on that card, not that.
You don't think this would create a lot of litigation?
The gentleman's time is up. There's a vote occurring on the floor, and we want to try to finish up the questioning before we have to recess for the vote. The gentleman, Mr. Scalise, the gentleman from Louisiana. I'm sorry. Okay. Dr. Gingrey is recognized for 5 minutes.
Mr. Chairman, thank you. Sometimes myself and Mr. Scalise get confused. He likes to walk around saying he's Dr. Scalise, but we know better. Mr. Chairman, thank you. I want to address my question, the first question to Mr. Ramminger. In your testimony, you discussed the need to hold the prepaid calling industry accountable for the current abuses in the system. However, you also discussed the need for your industry to be held accountable only if they know about the incorrect information on the calling cards that are being distributed. Under the bill previously considered by the subcommittee,
that ultimately passed the House, there was an exemption for point-of-sale retailers if they sold these cards. Under the current version of this bill, that exemption for retailers no longer exists. So my question is this: how does this potentially affect your industry? And if you can speculate, the point-of-sale retailers for whom I guess you work.
Yes, that we supply. I mean, what we're basically asking for is that the protection that was in the original legislation last time around that protected the retailers be extended to our distributor members. And I again want to make the distinction between our distributors who are buying candy and gum and snacks and phone cards and selling it to the retailers, and the quote-unquote distributors that are sometimes called distributors. They're buying minutes from a long-distance company and making cards. That's a different kind of distributor. So, yes, sir, what could happen is if, through no fault of his own, one of my members buys these cards from what is essentially a manufacturer of the cards and sells them to a retailer, believing what the manufacturer of the card has said, that there are 10,000 minutes or however many minutes it says there are. The person who should be the entity that should be held accountable if there are not that many minutes is the entity that created the card, we believe, not the distributor or the retailer. And we don't believe it would be appropriate for our distributors to be fined $16,000 every time they sell a phone card. That
Mr. Ramminger, thank you. I understand your response. And let me go back then to Ms. Greisman, because I got a little confused. Just a moment ago, you asked to correct something that you had said. Do you disagree with Mr. Ramminger, or do you now agree with him that point-of-sale folks are different than those who are the so-called distributors who buy the minutes, who put them on the card, and the bad actors that can monkey around with what's really in? Is there any disagreement with what he just said, in your opinion?
Yes, let me clarify. Thank you. My interpretation of the bill is that by virtue of the way distributors is a defined term there, that retailers are not covered. So retailers are out of this particular bill. I would not support taking distributors out, and I would cite to the fact that the 3 cases the FTC has brought have involved have involved distributors.
So you wouldn't be in favor of taking the point-of-sale folks out of
Point-of-sale people, to the extent they are the ones I would characterize as retailers, already are out of the bill as drafted.
Let me ask you, Ms. Greisman, another question. Do inconsistent state laws place service providers in an untenable situation by prohibiting activities in one state that are permitted in another? Are prepaid calling card services usually tailored on a state-by-state basis, or are they generally uniform throughout the United States?
Sir, my understanding is that 11 states have discrete statutes or regulations that do, in fact, tailor the treatment of prepaid phone card industry currently. I'm not aware that that has led to conflicting results or problems in an industry that, by all calculations, appears to be thriving.
Yeah, but wouldn't it be easier and more efficient to coordinate with the states on enforcement actions if there was a single standard?
It might be, but I don't believe having different standard has created any problems to date or necessarily would going forward.
Dr. Greenberg, it seems like your time is
Mr. Chairman, thank you. I didn't realize I didn't.
Right. I didn't either.
Yeah, I yield back. Thank you.
Thank you so much. Now, Dr. Scalise.
I only play when we're talking about the health care debate, I guess. Thank you, Mr. Chairman. I know we have votes, so I'll try to run through this real quick. First, Ms. Greisman, earlier I think in your testimony you talked about some of the bad actors, the worst actors in the prepaid industry are now moving over to the wireless market. First, do you have a list of those worst actors, and have y'all been taking any action against them? as they've been doing things both in dual industries, both prepaid and wireless?
Sir, we don't have jurisdiction over them. We're talking about carriers that would migrate into the wireless space. We currently have no jurisdiction over common carriers. But what I can say is that we've seen the advertising and marketing for the wireless prepaid phone card services looks significantly similar to in the non-wireless space, and in particular, we do see that they are targeting immigrant populations.
Have you taken action against them on the prepaid side?
We do not have our prepaid phone card cases have involved only distributors.
And if I could go back on Mr. Ramminger, I know it seems like there's a little, I don't know if it's a rift or the definitions. Obviously there's a dispute between on distributor. Is the definition of distributor first in a way that you feel is fair, but also when the statement that retailers are out of the bill, are y'all comfortable with that too? Do you feel that the people that really don't have any part in, if there is fraud going on, they have no part in it, but are they really being pulled into it?
Yes, I mean, I think it's fair to say that we certainly support taking the retailers, the liability away from the retailers. What we're saying is we also believe that our distributor members, similar to the retailers, are buying from effectively a manufacturer. Occasionally the people who make these cards, because they're buying minutes, they're not selling widgets, they're buying minutes and putting them on a card. Those guys are referred to as distributors too. That's where I think the confusion is coming in. Our guys are not buying minutes and putting them on a card. They're simply buying the cards and selling them to the retailer who's selling them to the consumer, and we don't think we should have to be liable, and unless it can be shown that somehow the distributor
that you're doing something deliberate or there's harm intended. I appreciate it. I know we got to go, so I yield back.
The chair thanks the gentleman. The chair thanks all the witnesses for the gracious use of your time. You have sacrificed a significant portion of your busy day to us, and we really appreciate your testimony. It's been very enlightening and rewarding for us all, and you certainly have illuminated a path for us as we proceed with this matter. I would just ask that you be available to us for members to submit their questions to you in writing, and that if you would respond within 2 weeks to those questions, we would be delighted. Again, we thank you so much for your time. We do have a vote, so we'll rush it over to the floor in order to cast 4 votes. Thank you very much for your presence, and the subcommittee is now adjourned.